Hello and welcome to part 2 of the JGLS Insolvency Law Public Lecture Series. I'm very excited for today's speaker and I hope that you are too after the extensive Googling that you have done already to know more about this speaker. Now, Sheila Ung is a powerhouse. She's a fellow of Insol International and is one of the first 3 qualified lawyers to have earned this recognition. She has been at the forefront of major insolvencies in Singapore and has acted, continues to act for liquidators of IMF Global Singapore, BSI Bank, and also the various Lehman Brothers Singapore entities, which is going to form a part of the conversation that we're going to have today. Now, she also holds a title, which is partner at Raja & Tan Singapore, where she routinely handles restructuring and insolvency, fraud, asset recovery investigations, and commercial litigation. She was featured recently in the Global Investigations Review 40 Under 40, a list of 40 accomplished young investigation specialists from all over the world. She was recognized in the 2019 edition of Who's Who Legal as a future leader in the field of investigations, and was also featured as one of the 100 female investigation specialists in the Global Investigations Review, Women in Investigations 2018. Much of her accolades are still missing from my introduction, but we'll be here for the entire duration of the hour if I begin to introduce the speaker in detail. All I can say is that she's a woman powerhouse, and I'm very excited that she has agreed to give this lecture on Lehman pre and post 2008, with a Singapore perspective on corporate insolvency and restructuring. So without further ado, I want to say welcome, Sheila. It is exciting and incredible to have you give this particular lecture. And I want to start with this myth-busting statement. So one of the things that has always been conversational and put to question is the multiple laws that India has vis-a-vis restructuring, vis-a-vis insolvency, winding up, liquidation, schemes of arrangement, and other methods like arbitration in the aspect of debt recovery, debt resolution, debt restructuring. Do a little bit of myth busting and confirm that we're not alone in this world as a jurisdiction.
Thank you, Ishana, for the very kind introduction. The Insol Fellowship course has run for many more years before myself and the other 2 first Singapore qualified lawyers, joined Insol Fellows. So we were very honored to be, part of that class in 2018. And we're also very excited to be here today to share some thoughts with you from the Singapore perspective. As you were asking me in relation to the various laws that Singapore has, a multitude of restructuring insolvency laws that cater to both the restructuring part of it as well as the liquidation aspects. And I will talk a little bit more about it, as we go along in the next 1 hour. But what Singapore has recently done is to consolidate that. So before 2017, we had the Bankruptcy Act, we had the Companies Act that dealt with corporate insolvency regime as part of the Companies Act, the bankruptcy individual regime in the Bankruptcy Act. What we have now tried to do, what we have done is to unify all the provisions in relation to restructuring and insolvency, both individual and corporate, into one single legislation, so that it's easier, it's a bit more uniform in terms of the application of the laws.
Thank you for that brief background, Sheila, which kind of segues into the next question, which is, Singapore has also recently introduced many amendments to its restructuring and insolvency laws. And this is partly in a bid to promote Singapore as an international debt restructuring hub. Now, how has the law around debt default resolution evolved in Singapore? Is this a 2008 post phenomena, which is essentially when Lehman happened and you were very much involved in the process of the Singapore element of the restructuring of the Lehman entities and the Lehman Protocol. It may not be as talked about in the rest of the world, but the Singapore leg was a very big part of the Lehman case. Talk to us a little bit about what happened at that time in that case and the legal evolution post that.
Yeah. So in 2008, of course, that was the global financial crisis, and also with that, of course, the collapse of Lehman that, resulted in, various insolvency proceedings commenced all over the world. Singapore's decision, as part of its ongoing review of the insolvency laws, started in about 2010. So just shortly after the global financial crisis, and also, I suppose you can say that it's sparked by the various liquidation cases, the insolvency cases that sparked as a result of the financial crisis, to review the existing bankruptcy and corporate insolvency regimes. So what had happened in 2010 was that a law reform committee was set up, basically with the objective of modernizing and unifying Singapore's regimes of bankruptcy and also insolvency in a single piece of legislation. And it was only recently, on 30th July 2020, that both Singapore's bankruptcy regime, as well as the corporate insolvency regime, was unified in one single act called the Insolvency Restructuring and Dissolution Act. So now we have a single piece of legislation as of last year, 2020. Back in 2010 and 2008, thereabouts at time, Singapore's insolvency regime had not yet been fully developed, in particular to deal with cross-border insolvencies. And this was something that the Law Reform Committee was tasked specifically to look into as well. At that point in time, the Companies Act, which had also dealt with other general provisions in relation to companies, incorporation of companies, the dealing with shares and directors. And there was one separate section there in that Companies Act to deal with insolvency. It only provided for how a foreign company, either registered or unregistered in Singapore, may be wound up. It didn't deal with what happens with cases where a foreign company with assets in Singapore, how is the insolvency proceedings going to be affected here in Singapore? That was all not dealt with under the old Singapore regime. The relationships also between foreign and local insolvency practitioners, and also the relationship between foreign and local insolvency proceedings, as well as the degree of cooperation to be provided, also continued to be governed largely by common law. It wasn't actually codified. It's not present in any legislative provisions. And that gave rise to a little bit of uncertainty, even though there is common law to provide for it. As you may expect, with investors, they would like certainty. They would like to know that if they're going to put money into a country, what happens if things go bad? And so that's the reason why, in terms of the cross-border insolvency aspect, Singapore felt that it should be given greater legislative clarity. And that is also the reason why Singapore adopted the UNCITRAL model law on cross-border insolvency in March 2017. So that was part of Singapore's reforms to its bankruptcy and insolvency regime. At the same time, also in 2017, one of the exciting new introductions to the statutory regime for schemes of arrangement was in relation to cramp down mechanisms, rescue financing, terms that we hear quite a bit in Chapter 11. So these changes were aimed at placing Singapore on the map as an international debt restructuring hub. So you would then see, and I'll discuss a little bit later, in terms of the schemes arrangement, what were these elements? And what did we sort of try to do? It's sort of like a hybrid. Singapore's scheme of arrangement, it's a hybrid of the English in the English scheme of arrangement, as well as Chapter 11 of the United States Bankruptcy Code. In total, what we tried to do was to make it more attractive, user-friendly, and efficient, and hopefully it's more conducive to a successful restructuring outcome for the debtor companies. And all of these changes come at a time where businesses in the region are getting more sophisticated and also recognizing earlier the opportunity to restructure before it becomes too late. Before, typically, especially as a matter of culture, companies, would typically try to do its very best internally, and hold on to the very end. And sometimes it becomes too late and there is no way to turn the clock back and try to restructure the company, and the company goes into insolvency and has to be wound up. However, now we see that companies are becoming more sophisticated. Debtor companies are also seeking advice much earlier in relation to their restructuring options. Not just seeking legal advice, but also seeking advice from financial advisors in relation to how they could restructure their debt, or in fact, look also at operational restructuring, how they can actually restructure their business. So this is something that has been increasingly seen, especially in the context of the last 1 or 2 years for COVID. I think a lot of the companies are all recognizing the need, to actually clean up shop early and take advantage of the recovery, as the world recovers from COVID and the financial downturn. Turning the clock back to the global financial crisis in 2008, of course, most people will recall the collapse of Lehman Brothers. So Lehman Brothers Holdings Inc. Is a US entity. It's a global financial services firm. And before filing for bankruptcy in 2008, Lehman was one of the 4 largest investment banks in the US. It was doing business in investment banking, equity and fixed income sales, as well as private banking. So what had happened in 2008 September is that Lehman Brothers Holdings filed for Chapter 11 in the US. It was the largest, and I think it's still possibly the largest insolvency case where there is bank debt of over $600 billion, $155 billion in bond debt, as well as assets worth over $600 billion. Things had to move very quickly, as you would expect, because of the amount of assets, that was involved, and also the number and the value of the creditors, across the world. And in fact, within 2 weeks of the Chapter 11 case that was filed, parts of the clean business, the clean assets of Lehman in APAC, in Europe and Middle East was sold to Nomura, and also debt in the US being sold to Barclays. So there was a breakup of the business, and it was being sold. But concurrent with that, and that's what we're going to talk about in relation to the insolvency of the subsidiaries, is that the subsidiaries of Lehman across the world began to enter into their own insolvency process. Bearing in mind that Lehman, it's a global firm. It has operating entities all over the world, and it wouldn't have been directly held by just one entity, LBHI, so Lehman Brothers Holdings Inc. There would have been multiple layers. There would have been investment holding companies that would have in turn held, the operating businesses. So it was a complex web and structure of the various the entities. In Singapore specifically, these subsidiaries were placed into liquidation. And talking a little bit about liquidation, so that's the winding up of a business here in Singapore. In Singapore, the liquidation regime is twofold. One, voluntary. That means a company can voluntarily say that it wishes to be placed into liquidation if the requisite majority of shareholders wish to place the company into liquidation. And that's typically by way of a special resolution, so that's 75% of the shareholders. So a company can say, okay, I wish to wind it up. But a winding up needs to be considered whether it's an insolvent winding up or a solvent winding up. Because if it's insolvent, then the creditors' views are also important. The creditors do not have a say in terms of whether the company should be wound up, but the creditors have a say in who should be appointed as the liquidator. So as part of that voluntary liquidation process in Singapore, a creditors meeting will have to be called, and the creditors get to vote. If they decide that the appointed, the nominated liquidator, the liquidator nominated by the company is not suitable, or they don't agree with that, the creditor's choice prevails. Because at the end of the day, when it comes to insolvent liquidation, the law recognizes that it's the interest of the creditors that will rank first before the shareholders. But in the context of a solvent liquidation, where the company has more than enough assets to pay all its creditors, then there is no creditors meeting to be called. A liquidator will be appointed by the company, and then the liquidator will then have to resolve all of the liabilities, and then return and distribute the surplus in the estate to its shareholders. So that's on voluntary liquidation. We also, of course, do have a court-compelled winding up. An application can be made by either a creditor or even the company itself to court for an order of court winding the company up. That's also an option, especially in cases where it's the creditor, who wants to wind up the company because it hasn't been paid. And that's typically the case that we see most of the court winding up cases. So coming back to Lehman, so each entity is placed into liquidation separately, bearing in mind that as at 2008, and in fact, as of now in Singapore, there is no group insolvency regime. So there isn't a concept where a group of companies can all be placed into liquidation together. Separate liquidators would be appointed. However, it doesn't mean that they cannot cooperate. And that's something that we will talk about in the context of the Lehman Protocol. So with the amendments in 2017, I should also just highlight that while there is no group insolvency regime, per se, Singapore, however, recognizes that in the context of restructuring, so in the context of restructuring where a debtor company is trying to, get some breathing space from its creditors so that it can come up with a scheme of arrangement, a proposal to compromise debts, try to get some investors to come in to pump in money, and then pay out, some sort of distribution to its creditors. That takes time. And because that takes time, the company needs breathing space to be able to go and source for the white knight investor, to negotiate with its creditors on, an appropriate compromise. There is the concept of a moratorium that can be obtained statutorily in Singapore. This is also available not just to the debtor company itself, which is undergoing the restructuring and proposing the scheme of arrangement. It is also available to affiliates of the debtor company if it can be shown that it is a necessary and integral part to that scheme of arrangement. And this is very helpful in the context of a group company where they are trying, a group of companies where they are trying to restructure. And that's because a lot of the debts perhaps are held at the operating business level, because they're the ones who enter into the bank loans, for example. But at the same time, it's the whole co that also guarantees the debts of not just one subsidiary, but maybe 5 subsidiaries. And it could very well be that even though the operating company is still solvent on its own and can continue, it's the whole co that has gotten into trouble because of the accumulated debt across the subsidiaries. And in that case, simply a moratorium against the commencement of proceedings against the debtor company at the whole co level will not be sufficient, because if there is a default at that level, a bank or any other creditor could, with an interconnected debt in relation to a subsidiary, could commence proceedings against the subsidiary and put pressure on the whole co, and therefore causes an impediment to a restructuring at the group level. So with that gives group companies, some sort of breathing space. So with a group of companies, we can expect that, there will be cases, where accounts and records of one entity is maintained centrally by the whole co, or it could also be, maintained by another entity, or it could also be that, the cash in terms of cash flow, a lot of cash goes, from one entity to another entity by way of, intercompany loans. So when a group is very interconnected, there might be, issues that arise in the context of insolvency, particularly where there will be various intercompany claims. There may also be issues in relation to verification of the accounts or verification of records, or the inability to obtain records easily because these records belonging to company A is not in the possession of company A, but held in a server that is at the whole co level, or perhaps in a related company. So those are practical issues. How then do we deal with that? And this was the case in Lehman. So because Lehman operated as a global firm to various legal entities with multiple cross-border cash management and operating platforms, what the Lehman entities did was to come out with a cross-border protocol. So this is the Lehman protocol, as commonly called. And in fact, this is a copy of this is also available in the public domain. And I think in the last 12, 13 years, there have been various lectures and also seminars on this. This cross-border protocol is a non-binding agreement to promote cooperation, minimize costs, and also facilitate the conduct of multiple proceedings. The key terms and objective of the protocol are to promote communication and data sharing. So as I mentioned earlier, in terms of relevant data, it might not be in the possession of one particular affiliate. So the sharing of relevant data was intended to promote efficient, effective, and fair administration. Because if one affiliate was going to hold all the information to itself and not share, that would cause some problem with the administration of the other company. It also would avoid duplication in effort, as well as activities by the parties. And if you look at it globally for the group, it would be effective and also cost efficient. Bearing in mind that the higher the professional costs are in having to carry out these activities, it means less for the group, less for the company itself, that specific company itself, but generally as a group as well, insofar as there may be surplus in the estates that can flow up to the parent company at the end of the day. The Lehman Protocol also sought to preserve and enhance assets in the identification, preservation, and maximization of value of the debtors' worldwide assets. And this was for the collective benefit again for creditors and other interested parties. And very much linked to the issue of data sharing is claims reconciliation. So when it comes to claims that are intercompany, it could very well be an issue of whose records are correct. Is it mine that I maintain on an ad hoc basis, but there is actually a centralized system that everyone had been using in the ordinary course of business? Would it then be more appropriate that that centralized system be used as the basis for verification and of claims intercompany? So that's also something that to be thought about in terms of how that will be fair, if fair. And that depends on circumstances, of course, in terms of whether that is indeed the case during the ordinary course of business. At the end of the day, really the objective would be to consider what's a consistent and measured approach to the calculation and adjudication of intercompany claims so that we can avoid unnecessary intercompany litigation. Again, to maximize value for the group generally. It's also important to bear in mind that because there is no binding effect of the protocol, what the protocol simply sought to do was to establish a set of behavioral norms. So if you take a look at the Lehman protocol that's available on the internet, you would see they use the words should, right? Administrators should do this, so it encourages, it sets that norm so that it's realistic. And also it's meant to record a common understanding of values and goals amongst the various administrators. Another side benefit to the Lehman Protocol is that when parties come together to discuss the framework, to negotiate the framework, it also means that parties sit down at the same table. With that enhanced opportunity for face-to-face discussion, that also helps in terms of collaboration and cooperation by just being physically there, and giving that opportunity to also have side bilateral talks, and also giving rise to the opportunity to cooperate a bit more by simply saying that, since we're all here at this table now, let's talk about other things, and how these other matters will be for the benefit of all of our states. Resources can also be shared, just in terms of, for example, foreign counsel. If there are foreign counsel that will be able to act for both the entities, because these are not conflicted matters, it might also be more cost effective generally for the debtors. There are, of course, limitations to it. So on the flip side, because it's not a binding protocol, it does not bind participants. It's just a question of whether they will actually abide by it. It also does not deal with jurisdictional issues. The substantive issues still need to be dealt with. But this is intended to facilitate cooperation.
It's quite interesting that you're talking about the cross-border protocol and Singapore's viewpoint. Like tomorrow is when we talk about Jet Airways and the court-approved cross-border protocol, where the insolvency proceedings are in Netherlands, and this is without the support of an international instrument. It's a very amazing set of affairs to have happened presently between the Netherlands and India. Now, you have mentioned that Singapore has adopted the model law, and there is a lot of heated conversation around that presently in India. Could you elaborate on Singapore's adoption of the model law, the how and the why?
Thanks, Ishana. So the how and the why. So why? It's because Singapore wants to be a debt restructuring hub. With that, we need to be able to have the available mechanisms, for cross-border matters. Bear in mind that Singapore is a very small jurisdiction on its own. I mean, when it comes to local cases, it's limited to that number of local companies, that's concerned. But quite apart from that, in terms of even the local companies in Singapore, they also have assets outside, subsidiaries, outside of Singapore. So one is to enable, cross-border cases originating from Singapore, to give that framework in terms of what's beyond. But more importantly, also it's the other way, in terms of case where there are, multinational companies with subsidiaries in Singapore, or even if not in Singapore, but if certain debtors consider Singapore to be an appropriate jurisdiction to carry out its insolvency proceedings, Singapore's model law seeks to facilitate that. So under the model law, what the Singapore courts have to do is to recognize a foreign proceeding if certain stipulated conditions are met, unless recognition will be contrary to the public policy of Singapore. A foreign proceeding must be recognized as a foreign main proceeding if it's taking place in a state where the debtor has a center of main interest. So this is what we commonly call COMI, center of main interest. So there is a difference between foreign main proceedings and foreign non-main proceedings. Foreign main proceedings qualify for more extensive reliefs than foreign non-main proceedings. So bearing in mind again that foreign main proceedings is where the debtor has its center of main interest, COMI. And what are these extensive reliefs? The primary one, and the most important one, is that they qualify for automatic moratorium against the debtor and its property under Article 20 of the model law. And just to elaborate a little bit, what's a moratorium? Moratorium basically is a stay on proceedings. So you can't commence, legal proceedings against a company when there is a moratorium in place. And as I mentioned earlier, in the restructuring context, a moratorium gives the company breathing space. And that's a very important element, in a restructuring, so that the company can do what it needs to do. Having said that, of course, there have been cases where there is no need to go to court, for a statutory moratorium, because parties are able to enter into a consensual standstill. So if parties can agree, so the creditors agree to give the company itself, breathing space, then there is no need to go to court for that relief. But it is not easy, to enter into a consensual standstill agreement, unless if the number of creditors is smaller, it's a bit more manageable. Also, if the creditor itself is willing to talk, is willing to actually give that standstill. So Singapore is developing its case law as more cases come before the courts since the adoption of the model law in 2017. So for example, in terms of the determining of the debtor's COMI, when do we do it? When is the relevant date for doing so? These are all questions that have come up in recent years because it's not clear, or it's not expressly stated in the model law. And in doing so, the Singapore court has considered the various positions that have been taken across the world, in England, in Europe, in relation to this question itself, the European and English courts have used the date of commencement of foreign insolvency proceedings as the relevant date for determining the debtor's COMI. In contrast, the Australian position is the date of hearing of the recognition application, and the US position is the date of filing of the recognition application. So it's along that timeline of the different dates. Singapore has taken a view that the US approach should be adopted, and that's because it provides greater certainty and accords with the commercial realities in Singapore model law. This also facilitates forum selection. So Singapore endorses forum selection. There's nothing wrong, there's nothing objectionable for that to happen. In particular, and that's the reason why postponing the COMI determination until the application for recognition recognizes that various entirely legitimate measures may be taken to shift a nexus for commencement of insolvency proceedings, as opposed to the English position where it's the date of commencement of the foreign insolvency proceedings. Singapore takes the approach that it's also not objectionable for debtor companies to be given the autonomy to select the most appropriate jurisdiction to achieve an effective restructuring solution. Very briefly about what are the factors in determining COMI. So the material factors are the central management and direction of the company. And these are factors that should be objectively ascertainable by third parties generally. And the Singapore courts have also recognized in the context of group companies that it's possible to consider the activities of the entire group of companies and not just the debtor company when analyzing the COMI of the specific debtor company. So we take a little bit more pragmatic approach and we recognize the realities that in the context of a group, things happen, more broadly as opposed to each individual debtor company.
Now, the restructuring preference is clear, then, Sheila, because it's clear also that a restructuring preference in insolvency has allowed for a very strong regime, and the use of schemes of arrangement, which are not a preference in India in insolvency cases because the stakeholders are too many, people can't agree in most cases, and it's a lengthier process, but is very much the case in Singapore. Now, how are they used in cases? Could you elaborate a little bit on that, like in terms of schemes of arrangements becoming a part of restructuring in insolvency?
Yeah, schemes of arrangement have been a part of Singapore's restructuring insolvency landscape since 1967. So it has been about 50, 60 years that it's been in place. But the regime has gotten stronger. It's now certain measures have been actually introduced to make it more debtor friendly and to enable debtors to use that to their advantage in trying to restructure the company. So prior to IRDA, the procedures for a scheme of arrangement was set out in the Companies Act, as I earlier mentioned. What had happened in 2017 as part of the legislative reform was that the Companies Act was amended to significantly enhance the scheme of arrangement regime. It introduced improved statutory moratoriums. It allowed for the concept of a pre-packed scheme. And this statutory regime, as amended in 2017, was then transplanted into IRDA with only very minor modifications, but it's essentially the same in terms of that. So going into the scheme of arrangement, what exactly is that? It is an agreement between the company and its creditors, containing terms that allow the company to restructure and meet its debt obligations. So it's like a contract in that sense. The only difference there is that when a scheme of arrangement is sanctioned by the court, notwithstanding that there are creditors who have dissented, they will nonetheless be bound by the scheme of arrangement. This scheme of arrangement also is primarily a debtor in possession rehabilitation process. But the company's existing management is not displaced in favor of a court-appointed officer, which therefore means the management continues to run the company throughout this process. It's not subject to any supervision of the court or by any court-appointed officer. Schemes are also So in terms of, sorry about that. So in terms of the scheme process, traditionally, there is a process for it where the company must first apply to the court for leave to convene a creditors meeting, the purpose of which is to approve the proposed scheme of arrangement. Typically at that time, what the company will also do is to apply for a moratorium to be in effect during this time while the company negotiates, prepares for the creditors meeting itself. At the creditors meeting then, the scheme of arrangement is put to the creditors for approval, and it must be approved by a majority of the creditors present and voting in each class, and this majority must represent 75% in value of the voting class. And it is only when the requisite majority is obtained that the company can then go to court to obtain sanction of the scheme. Even though the creditors have approved it by the requisite majority, the court still has the discretion and may not sanction the scheme. So it depends on the court's discretion at the end of the day. This is to ensure that there is no abuse and that the court remains available to sanction the scheme and to make sure that everything is in order. It's only upon sanction of the scheme that it becomes binding on all creditors, regardless of whether the creditor was a dissenting creditor or had approved the scheme. But what's important that with the 2017 amendments, there is a cross-class cram-down mechanism that was introduced, which meant that even if there was a class of creditors which did not approve the scheme, so long as certain conditions were met, the scheme can still be approved. And that is if in general, across the board, a majority in number of the creditors meant to be bound by the arrangement, and also 3/4 in value of the creditors have all said okay and approved the scheme. And the court is also satisfied that the compromise or arrangement does not discriminate unfairly between two or more classes of creditors and is fair and equitable to each dissenting class. You would then ask, what is fair and equitable? In considering this question, the court would focus on whether the dissenting creditor would receive under the proposed scheme an amount less than what such a creditor would receive if the proposed scheme was not approved. So you would then ask, why would there be different classes of creditors? Wouldn't it be a case where it's just one scheme and a whole group of creditors? The reason for different classes is because we recognize that there might be creditors in different categories or different groups with different interests, and therefore they will not be in the same position. They'll have different rights, and therefore will not be in a position to make decisions from the same perspective. And the very clear distinction between classes is that of secured creditors and unsecured creditors. And that's because in terms of secured creditors, they already have security that they can look to. The amount that they will be able to get from the property itself without a scheme will be the value of the property as compared to the unsecured creditors, where the starting point is different. It also provided for additional safeguards against abuse in respect of cross-class cram-downs by expressly requiring that junior claims. And what are junior claims? Claims that are subordinated to the claim of a creditor in the dissenting class do not retain any property unless the more senior claims are paid in full. So this is the absolute priority rule. But in practice, this meant that shareholders as junior claimants could not retain their shares unless the secured creditors as the more senior claimants were paid in full. In practice, however, this created some sort of practical difficulty because Singapore did not have a mechanism to compulsorily divest shareholders of their shares in the company. So therefore, the cross-class cram-down was therefore dependent on the shareholders' voluntary cooperation to sell their shares, to give up their shares, which might not be forthcoming in practice. So therefore, in the new order, the relevant section was then clarified to ensure that there was that possibility of shareholders being allowed to retain their shares before a cram-down can be made. And one other thing in relation to enhancement of the scheme of arrangement process is that of a pre-pack scheme. And this is a concept that, is widely used, in the US or even in the UK. And that's where there is no need for a creditors meeting to be called. It's like a fast track scheme of arrangement where there is no creditors meeting to be called. And what simply happens is the debtor company has to be able to satisfy the court that had a creditors meeting been called, the proposed scheme would have been approved by the statutory majority. And we have seen it being used in Singapore on various occasions, particularly where the group of creditors is smaller. And there has already been, very active dialogue and engagement with the creditors, and the creditors have all, have said yes. It doesn't have to be all, but the requisite majority of them, have said yes. And we then do not have to call for a formal meeting again to get that approval, and we can just go straight to court for sanction of the scheme of arrangement. I think one other important thing, in terms of the amendments in 2017 in Singapore, is that of the statutory moratorium, and how that has, been widely used in Singapore. And that was what we used to call Section 211B under the Companies Act, and it's now Section 60 of the order. And that's because upon an application to court under Section 211B or Section 60, this is an application for a moratorium against the debtor company. There is an automatic moratorium of 30 days that kicks in upon the filing of the application. And this is important because it then gives the debtor, that breathing space with that 30 days automatic moratorium. To prevent abuse, the courts have increasingly been, more strict in its criteria in making sure that the companies who make that application have to tick the boxes, have to already, seek the, support of creditors, and also must already have, salient terms of the proposed scheme of arrangement ready. It will not be enough to have, broad bullet points of a scheme of arrangement that we intend to enter to a debt restructuring. The debt restructuring will generally, contemplate a return, of, some monies to the creditors, without there being concrete details of what would go into the scheme of arrangement. This is to ensure that it will not be abused, and that debtors cannot just simply make applications for a moratorium on the purported pretext of a scheme of arrangement that has no meat yet. And one other introduction that has been important and also facilitates restructuring in Singapore is that of super priority rescue financing. So again, we have taken a leaf out of the US in terms of that rescue financing. So to obtain an order for super priority, apart from convincing the court to exercise its discretion, the company needs to show that the proposed financing to be given while the company is insolvent constitutes rescue financing, and also that the conditions under the limbs of the Companies Act, specifically in relation to what is being sought, has been met. Importantly, for purposes of today, it's that rescue financing is not just financing per se. There must be satisfaction of the rescue financing, meaning the debtor company is undergoing financial difficulty, and also the financier does not have any obligation in the first place to inject funds that will be advanced as part of the proposal. So it's meant really for rescue financing and not that it's an existing loan already. And in fact, on this front, we have been seeing more rescue financing cases here in Singapore. And also it's getting more sophisticated in terms of the mode of the rescue financing. In fact, in a recent decision relating to the Design Studio Group, the Singapore courts approved a $62 million USD rescue financing package relating to the Design Studio Group and 5 of its subsidiaries, which incorporated a roll-up of a bank lender's pre-existing debt. And what's a roll-up? A roll-up is a feature of a rescue financing deal which upgrades the priority of a rescue lender's pre-existing debt into a super priority debt, which therefore means that in terms of the new money that comes in, that new money, a portion of it goes towards paying the pre-existing debt of the rescue lender. So therefore, it's being converted or rolled up into the super priority rescue financing debt. This, encourages existing lenders to continue to give financing to the company, even though the company has, not performed its part of its obligations under the loan. And also shows how Singapore's debt restructuring regime is becoming more sophisticated. I should also add that as part of our restructuring and insolvency regime, apart from the winding ups, the scheme of arrangement, which is on the other end of the spectrum as a debtor-led restructuring, there is also something called the judicial management process in Singapore. And as part of the judicial management process, a scheme of arrangement can be proposed by the judicial manager. So judicial management is quite similar to the English administration regime, and is intended as a mechanism through which potentially viable companies could still restructure their liabilities and go through a rehabilitation. But the difference between that and a scheme of arrangement is where a judicial manager is appointed to oversee the company, displacing the existing management, which is what will happen in the scheme of arrangement where it's debtor-led. And as part of the judicial management process, one of its objectives that could be attained as part of the process is the implementation of a scheme of arrangement. It could also be the preservation of the company's business as a going concern, or obtaining a more advantageous realization of the company's assets than on winding up. We have seen in recent times in Singapore that judicial management has become more popular with the creditors, as a means of saying that I prefer having a court-appointed officer oversee the process as opposed to the management. And this is typically in cases where there is that level of distrust already with the management, or there have been some allegations that of financial misconduct or mishandling by the judicial manager. And this can be seen in quite a few of the oil and gas cases in Singapore last year. So for example, in agri-trade, as well as the Hin Leong and Ocean Tankers matters, where the companies were placed into judicial management.
Now, Sheila, very interestingly though, because schemes of arrangement are a part of the judicial management process also, you are looking at Singapore, and this is just to contextualize for India, Singapore also having a regulated M&A sort of framework. And it's interesting because oftentimes for the Insolvency and Bankruptcy Code, I do say that we are essentially enabling and regulating M&A as a part of restructuring under a particular law. Now, here I want to sort of refer to the last yesterday's lecture, where we decided to have Singaporean creditors and assets in Singapore and contracts under Singaporean law, but there was airline restructuring, which was happening in the UK. How would you advise your Singapore, assuming that this particular entity did come to you, how would you advise this particular creditor? And let's just assume that these are unsecured creditors with assets in Singapore.
Yeah, thanks for that, Ishana. So it's quite interesting that I guess 2 days in a row we do have discussion about Singapore as well in the context of the UK. So the fact that the creditor is sitting in Singapore, insolvency proceedings are in the UK, and assets are in Singapore. Of course, from the creditor's perspective, if there is no recognition of the insolvency proceedings here in Singapore yet, and it's just merely the assets that are available here, and it's not being protected by any moratorium. If a creditor wants to be aggressive about it, already has, for example, a court judgment in its favor, could always seek to enforce, and basically enforce against the assets of the debtor company here in Singapore. But one would then expect very quickly that the debtor company will make a recognition application in Singapore and asking for a moratorium. And that's where, and what we have earlier discussed, into the context of the model law, is that when the recognition application is made in Singapore, it's likely that it would be recognized. And the effect of that would therefore be there will be a moratorium. And from the creditor's perspective, then the creditor will not be able to continue any proceedings against the assets here in Singapore. So that's how, things are likely to turn out practically because of the model law. And that's how it also helps from the debtor's perspective, in ensuring that everything can be, looked at holistically.
So cross-jurisdiction, multiple entities, group insolvencies, this is the big conversation that is happening right now, along with pre-packs. And we will already cover pre-packs to a certain extent. And looking at how different regimes have incorporated prepackaged insolvencies and group insolvencies, what are the plugins that the new framework on the group enterprise insolvencies places that are presently missing in the cross-border model law? And before we answer that, perhaps just a little insight on how Singapore has in the past treated group insolvencies. So what is the take on the treatment in cross-border, and what is the general take that Singapore has on group insolvencies? Would be a very interesting and relevant perspective right now for India.
Yeah. So in terms of group insolvencies, because there isn't anything in the legislation that deals with that at the moment, save for what I mentioned in relation to the moratoriums for group companies. But practically, what happens is that if there is a group insolvency or various affiliates are all in insolvency proceedings, it's typically the same judge that hears the matters. So it's heard on a consolidated basis. It'll be one hearing, one judge, so therefore there will be some consistency in that. And even though there isn't any formal regime in relation to how to deal with issues that arise in the context of the Lehman Protocol, for example, we have seen the Singapore courts take a very active approach in encouraging the debtor companies or the insolvency practitioners or the creditors, to come up with solutions. Get all stakeholders together to consider, whether a protocol will be, appropriate. So in the context of a recent case where there were many creditors that were, that had similar claims against the company that related to certain assets, there was going to be a question of, it's not going to make, sense to keep coming back to deal with each of the creditors' separate application. The court did actually, sort of explore with parties and, suggested about a protocol. Is there a way to come up with something, that the court can sanction and that can then deal with each of the subsequent cases that come? On its own facts, of course, that's different, but at least the mechanism, the measures that we put in place would be something that's common across. And it will also aid the resolution of matters outside of court with that protocol that is put in place. So that's how we have dealt with it practically in trying to look at it holistically and having a common set of protocol that's being put in place. And of course, the things that are missing in the cross-border model law is that in relation to the enterprise group insolvency that Ishama had mentioned. And that's because the model law is designed to deal, or it doesn't actually address, multiple debtors. It only talks about a single debtor cross-jurisdictional insolvency. Whereas a group enterprise by definition involves more than one entity, often interconnected by control or significant ownership. And control typically relates to the operating and financial policies of an enterprise. So we can say that they are financially connected in that sense. So to address the interconnecting economic interests of the group members, there is the enterprise group model law that introduces the concepts of the planning proceeding and also the group insolvency solution. I must add that at this point in time, the jurisdictions have not adopted the enterprise group model law, but hopefully we get there sooner than later. And what the group insolvency solution and planning does is that the group insolvency solution refers to a proposal or set of proposals developed in a planning proceeding for the reorganization, sale, or liquidation or some or all of the assets and operations of one or more of the group members, with the goal of protecting, preserving, realizing, or enhancing the overall combined value of these enterprise group members. This set of proposals is intended to be developed through a planning proceeding. The planning proceeding is a proceeding where a group representative is appointed to represent each of the members. So this is one forum itself where the relevant members are all at the table and they can contribute to the solution. This is to ensure that discussions of group insolvency are all centralized in one forum, and a common solution can be, created by these members. While the model law on group enterprise has yet to be adopted by jurisdictions to have the force of law, it doesn't mean, however, that the concepts in the model law cannot yet be employed now. So, for example, in a speech given by Justice Kanan Ramesh, a judge in the Singapore courts, at a Texas International Law Journal Symposium in February this year, Justice Ramesh had observed that Articles 28 and 30 on synthetic proceedings do not have to be adopted as part of national laws for them to be employed, and also commented that it is always open to the stakeholders to embrace the concepts in the model law in any insolvency on a case-by-case basis. And what's a synthetic secondary proceeding? This refers to moving the resolution of issues in secondary proceedings to the main proceeding on the undertaking that the laws of the secondary proceedings would apply to the resolution of these issues, thereby obviating the need to open parallel proceedings. So therefore, a single forum is able to deal with all the key issues, which lends to a more efficacious or outcome for the insolvency. I will also touch very briefly before we end another piece of model law, and this is the Ancestral Model Law on the recognition and enforcement of insolvency-related judgments. You might ask, what is this piece of model law about, and why is it necessary, in the context of the existing Ancestral Model Law on cross-border insolvency? And that's because there may be some uncertainty with respect to the interpretation of Articles 7 and 21 in particular of the Ancestral Model Law on cross-border insolvency in terms of providing the necessary authority for recognition and enforcement of insolvency-related judgments as a form of relief available in the existing model law. Some may say that the model law only relates to the recognition of the insolvency proceedings itself and giving relief, for example, assistance to the insolvency practitioner, but doesn't actually deal with the recognition of insolvency-related judgments. Whereas it could also be said that it could be looked at broadly to also encompass that. To the extent that courts are recognizing the insolvency proceedings, that should also give the same jurisdiction to also recognize orders and judgments that are made in those insolvency proceedings. In Singapore, there is no case law on this yet. So we are, waiting for, I guess, the appropriate case to come before the Singapore courts. And just as a side note, even before the model law was enacted in Singapore, there is common law that provides for the discussion on the recognition of insolvency-related judgments under the common law regime. So that's how, even though the model law was not available in Singapore at that point in time, before 2017, common law had actually provided for the enforcement and recognition of foreign insolvency proceedings, as well as judgment as well.
That's a very interesting perspective on enforcement of judgments, because in general, in India, it has been slow, not in terms of decreasing, particularly before insolvency winding up cases. So we've generally become treaty shy based on the number of BITs we seem to be losing. So one has to just wait and watch on how an international instrument will be adopted. But before I let you go, Sheila, another big development that will happen in 10 days is after spending a year in suspension, the insolvency law being suspended in India. That was something that was similarly adopted as a COVID response in Singapore. We are going to come out of this suspension, and there's real sort of two minds in terms of what is going to happen once this suspension is lifted. What happened in Singapore, like in that duration, post suspension, during suspension? What was the sort of environment of law in Singapore?
Yeah, so we have already lifted the suspension on our end in Singapore. And what we have seen is an increase in the number of bankruptcy and also winding up cases. But I don't think it has been exponential. And I think the reason for that is that the banks, the bigger creditors are still willing to give that bit of indulgence, recognizing that the companies are in the midst of restructuring. And that's why I also said that in the last 2 years we have seen businesses being more sophisticated, and also doing things earlier to avoid that situation. But in aid of the that process in terms of restructuring, what Singapore has also done is to introduce a simplified insolvency program, which seeks to support micro and small companies to restructure debts wind up. Bearing in mind that the Singapore regime already provides for the legal mechanisms, but it may be seen as in the context of the very small companies, when there's going to be so many of them that same situation, that it might become a bit too expensive or a bit too costly, or it's a time-consuming process for that. So we have simplified that, and it's applicable only to the small and micro companies, to try to enable these companies to restructure or to actually go into liquidation with more cost-effective measures put in place.
Much to take away from that, and one can only now wait and watch what the consequence of the suspension being lifted in India will be in the next 10 days. And with that, I think it's only right to let you go, sharp time, and say thank you very, very much. To the audience, we're real-time responders of questions. So if you have any, you can write to the speaker, or you can write to me and we will respond to you. If you want the lecture to be repeated every month or every 3 months by this particular speaker, please do not badger the speaker. Please write to me and we will try to make it happen. And hopefully in person, once travel becomes more convenient and vaccinations and safety becomes even more sort of cemented. And with that, I want to say thank you to everybody who tuned in. Thank you very much, Sheila. It was an incredible insight and lecture. And I know to make it concise is always a challenge, because insolvency law and restructuring is an ocean, but you've done it fantastically. And I'm very grateful for the hour that you have spent with us. So thank you, everybody. Good evening and good afternoon, wherever you are. Bye-bye.
Thank you very much, Ishana. Thank you for having me.